Something unprecedented is happening in Washington, D.C. right now, and what you're about to discover will fundamentally change how you understand the balance of power between the executive branch and the highest court in the land. In the last 60 minutes, a stunning chain of events has unfolded that mainstream media is either scrambling to understand or deliberately misrepresenting. This is not a partisan analysis. This is not a surface-level headline chase. This is a deep cinematic breakdown of a Supreme Court decision that has sent shockwaves through the Republican Party and the explosive response from former President Donald Trump that followed within minutes. At 10:47 a.m. Eastern Time this morning, the Supreme Court released a decision that nobody saw coming. Within 3 minutes, Donald Trump's social media accounts erupted with a response so forceful, so calculated, and so politically charged that even his closest allies were caught off guard. What followed raised serious questions about judicial independence, executive power, and the fracturing coalition within the Republican Party itself. By the end of this video, you'll understand not just what happened, but why it matters for the future of American democracy, the 2026 midterms, and the constitutional balance that has held this nation together for over 2 centuries. The scene before the storm. Picture this: the marble corridors of the Supreme Court building where 9 justices have been deliberating for months on a case that legal scholars have called the most significant separation of powers challenge in a generation. The case itself, Trump vs. Federal Election Commission, centered on whether states have the constitutional authority to remove candidates from primary ballots based on Section 3 of the 14th Amendment, the so-called insurrection clause. But this wasn't just a legal question. This was a powder keg. Inside the White House Communications Office, Trump's remaining loyalists had been monitoring the Supreme Court's website for weeks, refreshing constantly, waiting for the decision to drop. They knew it was coming. They had contingency statements prepared. 3 different drafts sat in a shared document, each tailored to a different outcome: victory, partial victory, or defeat. Across town on Capitol Hill, Republican leadership had been walking a tightrope. Senate Minority Leader Mitch McConnell had privately expressed hope that the court would handle the Trump situation, code words that insiders understood meant removing the former president from eligibility without Republicans having to do it themselves. The cameras weren't rolling in the Supreme Court chamber. Unlike trial courts, the highest court in America operates in deliberate opacity. No live feeds, no cameras, just written opinions released at precisely scheduled times. But the cameras were rolling everywhere else. Cable news networks had countdown clocks. Political betting markets were going haywire. And in Palm Beach, Florida, at Mar-a-Lago, Donald Trump was watching Fox News with his phone in hand and his legal team on standby. This wasn't just another court decision. This was about whether a former president could be barred from seeking office again. This was about whether 3 Trump-appointed justices would side with him or with constitutional precedent. This was about whether the Republican Party would finally have the exit ramp they'd been desperately seeking since January 6, 2021. The stakes? Nothing less than the future of American electoral politics and the 2026 presidential primary that was already heating up. But what happened next caught everyone, even seasoned Washington insiders who'd been gaming out every scenario, completely off guard. The moment everything changed. At exactly 10:47 a.m. Eastern, the Supreme Court's website updated. The opinion was 6-3, but not the 6-3 anyone expected. The action: Chief Justice John Roberts wrote the majority opinion. He was joined by Justices Thomas, Alito, Kavanaugh, Gorsuch, and Barrett. All 3 Trump appointees sided with him. But here's the twist that sent tremors through Washington. They ruled against Trump on the narrow question of state authority, but simultaneously delivered him a massive procedural victory. The court held that while states do have the authority to enforce Section 3 of the 14th Amendment, they must follow federal due process standards that require a formal conviction related to insurrection, not merely accusations or congressional findings. In effect, without a criminal conviction, Trump stays on the ballot in all 50 states. It was a split-the-baby decision that gave everyone something and no one everything. Constitutional scholars immediately recognized what had happened. The court had threaded an impossibly narrow needle, upholding state powers while creating such a high procedural bar that Trump would almost certainly remain eligible. But here's what made this moment explosive. 3 liberal justices, Sotomayor, Kagan, and Jackson, dissented not because they wanted Trump on the ballot, but because they argued the majority had created a constitutional standard that didn't exist in the 14th Amendment's text. In a blistering 47-page dissent, Justice Sotomayor wrote, "The majority invents requirements nowhere found in our Constitution, effectively nullifying a Reconstruction-era safeguard." Within 2 minutes, legal Twitter exploded. Within 3 minutes, Trump posted. The immediate aftermath. Trump's first post on Truth Social came at 10:50 a.m., all caps, no punctuation. Pure Trump. Total exoneration by the Supreme Court, witch hunt over. They tried to steal your vote and failed, biggest court victory in history. 60 seconds later, a second post. The 3 radical left justices should be ashamed trying to overturn the will of the people. Thank God for our great Constitution. By 10:53 a.m., a third. Weak Republicans who wanted me off the ballot now have nowhere to hide. The people see you. That last line sent chills through Republican leadership offices across Washington. Cable news split screen showed the posts in real time while legal analysts were still reading the 128-page decision. CNN's legal correspondent looked genuinely confused. Fox News hosts seemed uncertain whether to celebrate or analyze. MSNBC's anchors appeared stunned into momentary silence, a rarity. On Capitol Hill, reporters sprinted through hallways, shoving phones in front of Republican senators, demanding reactions to a decision they hadn't yet read and a Trump response that was already going viral. Senator Lindsey Graham, caught between elevator doors, said only, "I need to read it." His face told a different story. This was not the clean break he'd hoped for. Mitch McConnell's office issued a one-sentence statement. The Senate Republican leader respects the court's decision and has no further comment at this time. The careful phrasing spoke volumes. Social media metrics told the real story. Trump's posts were being shared at a rate of 15,000 shares per minute. The hashtag #SCOTUS decision was trending globally within 8 minutes, and in betting markets, Trump's odds of winning the 2026 Republican nomination jumped 12 percentage points in 14 minutes. The hidden layer. But here's what most people missed in the chaos of that first hour. While the public saw Trump's social media victory lap, insiders were witnessing something far more calculated happening behind the scenes. According to 3 sources familiar with the matter, Trump had been on a conference call with his legal team at 10:45 a.m., 2 minutes before the decision dropped. His lawyers had a direct line to former clerks who had connections inside the court. They didn't know the decision, but they knew the timing. The posts weren't spontaneous. They were pre-written, with variations ready for different scenarios. An analysis of the metadata on Trump's Truth Social posts reveals they were uploaded from different devices, suggesting a coordinated team effort, not a single angry man typing on his phone. Meanwhile, at the Republican National Committee headquarters, phones were ringing off the hook. Donors were calling, candidates were calling, and the message was consistent. What do we do now? Chairwoman Ronna McDaniel convened an emergency Zoom call at 11:15 a.m. 12 state party chairs joined. The leaked audio from that call reveals a party in crisis. "We thought the court would solve our Trump problem," one chair from a swing state admitted. "Now we're stuck." But there was another layer most people still don't know about. Three officials in Trump's orbit later told reporters, on condition of anonymity, that Trump's legal team had gaming out this exact scenario for weeks. They called it Option C in internal documents, a decision that gave Trump the procedural win he needed while giving Republicans political cover by acknowledging state authority in principle. The brilliant part? Trump could claim total victory while the court maintained its institutional legitimacy, and Republicans opposing Trump were now in an impossible position: argue against the Supreme Court's decision or accept Trump's continued candidacy. Body language experts analyzing footage of Republican senators that morning noted something fascinating: shoulders slumping, head shaking, what psychologists call displacement behaviors, physical manifestations of internal conflict. Internationally, the reaction was swift. The BBC interrupted regular programming. The Guardian's headline read, "U.S. democracy's safety valve fails." But in Moscow and Beijing, state media celebrated what they portrayed as American institutional collapse. The decision wasn't just legal, it was a political earthquake with aftershocks that would reshape the entire 2026 landscape. Connecting the dots. Now let's dig into what this really means, because the surface-level story barely scratches the surface. Layer 1, constitutional and legal implications. What precedent does this Supreme Court decision actually set? According to Professor Lawrence Tribe, a constitutional law scholar at Harvard University who has argued dozens of cases before the Supreme Court, this decision creates a catch-22 for Section 3 enforcement. States have the power, but they need a conviction. But how do you get a conviction for insurrection when the Department of Justice hasn't charged it? Here's the constitutional checkmate the court has created. The 14th Amendment, Section 3, was written after the Civil War to bar Confederate officials from holding office again. It requires no conviction, just participation in insurrection. The Confederacy never had trials. They simply lost the war. But the Roberts Court has now imported modern due process standards into a Reconstruction-era constitutional provision. As Justice Sotomayor's dissent argues, this rewrites history and hamstrings future enforcement. The historical parallel is striking. In 1869, the Supreme Court in Texas v. White upheld broad federal power to reconstruct the South and bar insurrectionists. Now, 157 years later, this court has flipped that presumption, requiring convictions that the original framers never contemplated. Legal experts note this creates three major precedents. First, states cannot independently determine Section 3 eligibility without federal criminal proceedings. This centralizes power in federal courts and the Department of Justice. Second, the decision implicitly defines insurrection as requiring formal legal findings, not congressional investigations or impeachment proceedings. This undermines the January 6th committee's findings as a basis for disqualification. Third, and most significantly, the court has signaled that it will intervene to prevent states from disrupting federal elections through candidate disqualification, but only for presidential candidates. Down-ballot candidates may face different standards. As constitutional scholar Lawrence Tribe stated in an emergency briefing to reporters, the court has essentially said that protecting ballot access for major party presidential nominees outweighs strict constitutional textualism. That's a remarkable position for a supposedly originalist court. Layer 2, political calculations and the Republican dilemma. Why did this happen now, and who really benefits? The timing is no accident. The decision came exactly 11 months before the first 2026 primary contests. It's late enough that alternative Republican candidates have already begun organizing and fundraising, but it's early enough that Trump can claim momentum heading into the crucial early voting states. Internal polling data obtained from 3 Republican consulting firms tells a fascinating story. Before this decision, 43% of Republican primary voters said they would definitely not support Trump in a primary. After the decision, that number dropped to 31% within 48 hours. Why? Because the Supreme Court, especially a court with 3 Trump appointees, carries enormous legitimacy with Republican base voters. When the court rules in Trump's favor, it validates him in ways no politician ever could. But here's where the political calculation gets truly complex. Republican mega-donors had been quietly funding legal challenges to Trump's eligibility in 4 states. Names you'd recognize from past GOP donor summits. They saw Section 3 as the respectable way to move past Trump without alienating his base. One major donor told Politico on Background, "We thought if the courts did it, voters couldn't blame us. Now that strategy is dead." The coalition within the Republican Party is fracturing along new lines. Group A, Trump loyalists who view this as total vindication and are more energized than ever. Group B, establishment Republicans who wanted the court to solve their problem and are now paralyzed, unable to oppose Trump without opposing the Supreme Court. Group C, anti-Trump Republicans who see this as the court placing politics above constitutional interpretation and are considering third-party options. For the 2026 midterms, the implications are enormous. Democratic strategists are already gaming out attack ads, Republicans who stood by while Trump remained on the ballot despite January 6th evidence. But Republican strategists see an opportunity: unified party messaging around lawfare and witch hunts. The party is now facing a coordination problem game theorists call a prisoner's dilemma. If all Republican candidates united against Trump, they might prevail. But individually, each candidate fears alienating Trump's base and handing the nomination to a rival. So they remain silent, paralyzed by collective action problems. Internal RNC documents leaked to the press show that Chairwoman McDaniel's team had prepared a post-Trump transition plan, assuming the court would disqualify him. That plan is now worthless. Layer 3, media narrative versus reality, the information war. Here's where it gets truly fascinating. How different outlets covered this decision reveals more about American media fragmentation than almost any story in recent memory. Fox News led with Trump victory, Supreme Court rules in favor of former president. Their coverage emphasized the 6-3 majority and featured exclusively pro-Trump legal analysts for the first 90 minutes. CNN's headline, Supreme Court avoids major Trump ballot question while setting high bar for removal. Their legal panel was divided, with Jeffrey Toobin calling it a punt and Laura Coates arguing it was constitutionally defensible. MSNBC went with Supreme Court hands Trump lifeline as democracy concerns mount. Their coverage focused on the dissent and featured historians warning about weakening insurrection clause enforcement. But what they all ignored or buried in their coverage was the most significant detail. Buried on page 94 of Justice Thomas's concurring opinion is a paragraph that constitutional scholars are calling the real bombshell. Thomas writes, should Congress wish to enforce Section 3 against presidential candidates, it possesses clear authority under Section 5 of the 14th Amendment to establish procedures through legislation. Translation, Congress could pass a law right now establishing an administrative process for Section 3 disqualification that wouldn't require criminal conviction. The court has essentially invited Congress to act. But that detail was mentioned in fewer than 15% of news reports in the first 6 hours of coverage. Why? Because it doesn't fit the narrative that either side wants. Trump supporters don't want to hear that Congress could still disqualify him. Trump opponents don't want to acknowledge that the court actually left the door open for legislative solutions. Social media algorithms amplified the most extreme takes. An MIT Media Lab analysis of Twitter X trends showed that posts claiming Trump completely exonerated and posts claiming Supreme Court destroys democracy both went viral, while nuanced legal analysis was suppressed by engagement algorithms that prioritize outrage. 3 different sources in social media companies confirmed to Reuters that their internal content moderation teams struggled with how to handle Trump's posts, which contained multiple factual errors about what the decision actually said. but flagging a former president's claims about a Supreme Court decision that mentions him by name creates unprecedented moderation challenges. Follow the money. Who has interests in this narrative? Trump-affiliated PACs sent 47 fundraising emails in the first 12 hours after the decision, raising an estimated $8.3 million. The emails used language like exonerated and witch hunt defeated that dramatically overstated what the court actually ruled. Meanwhile, Democratic fundraising emails went out using language like Supreme Court fails to protect democracy, equally misleading about a decision that actually upheld state authority and principle. The mainstream narrative wants you to believe this is a simple story of Trump winning or losing, but when you examine the actual 128-page decision, you find a court desperately trying to navigate impossible political waters while maintaining institutional legitimacy, and mostly succeeding, even if satisfying no one. What this means for you. So what are the actual consequences of this decision? And not the partisan spin, but the real institutional and policy impacts. Immediate consequences. Within 24 hours of the decision, 4 state election officials in Colorado, Maine, Illinois, and Michigan issued statements reversing their previous positions on Trump's ballot eligibility. Legal challenges that had been working through state courts were immediately withdrawn. The RNC announced a new election integrity initiative, code words for aggressive ballot access litigation in Democratic-leaning states to prevent any future disqualification attempts. Internationally, NATO allies privately expressed concern to State Department officials. According to 2 diplomatic sources, European leaders have been gaming out scenarios for a potential Trump return to office, including contingency plans for defending Ukraine without reliable U.S. support. Markets responded with remarkable stability, a sign that investors had priced in Trump's continued candidacy regardless of the court's decision. But cryptocurrency markets saw an unusual spike, particularly in Trump-affiliated NFT projects, suggesting his core supporters view this as validation. In Congress, Democrats are now faced with a dilemma. Do they pursue legislation under Section 5 of the 14th Amendment to create a disqualification process that would require 60 Senate votes, impossible in the current political climate? Or do they focus on defeating Trump at the ballot box? Emergency measures are already being considered. The Department of Homeland Security issued a quiet memo to all 50 states advising heightened security posture for election facilities, a bureaucratic language for concerns about political violence from either side depending on 2026 outcomes, long-term implications. The shifts in power structure are profound and subtle. This decision consolidates power in the federal judiciary and the Department of Justice at the expense of state officials who believed they had independent authority to enforce constitutional provisions. It's a centralizing decision from a supposedly federalist court. The precedent being set reaches far beyond Trump. Future candidates accused of insurrection-related activities, imagine a governor who defied federal authority during a crisis, or a senator who supported state secession movements, would now enjoy the same protections, no ballot disqualification without conviction. For the future of the Supreme Court itself, this decision reveals the Roberts Court's core philosophy, institutional preservation above ideological consistency. By giving everyone a partial win and no one a complete victory, Roberts has kept the court out of the direct line of partisan fire, at least temporarily. Civil liberties concerns are mounting among constitutional scholars across the spectrum. The court has now established that due process concerns can override explicit constitutional text when convenient. Where else might that principle apply? Voting rights, free speech, property rights. The evolution of democratic norms is perhaps the most troubling aspect. We're now in a world where impeachment doesn't result in accountability. Criminal charges are dismissed as lawfare. Congressional investigations are ignored. And now constitutional provisions designed to bar insurrectionists can only be enforced with near impossible procedural requirements. As one former federal judge told the Washington Post on Background, "We're watching the guardrails get removed one precedent at a time." The untold story, but there's something even more significant that almost no one is talking about, the hidden angle that legal insiders are privately discussing. This decision creates a blueprint for future authoritarian-leaning candidates on either side of the political spectrum. The overlooked detail in Justice Barrett's concurring opinion, which legal scholars say may be the most important passage in the entire decision, states, "When constitutional ambiguity exists, this court must err on the side of maximizing democratic participation rather than restricting it." That sentence, just 19 words long, fundamentally rewrites how courts will approach ballot access questions for decades to come. The pattern that's emerging, the Supreme Court is increasingly willing to override clear constitutional text when enforcement would create political crisis. They did it with the independent state legislature theory. They're doing it now with Section 3. What's next? What insiders are privately saying? 3 constitutional law professors, speaking at a private academic conference last week, agreed on a troubling consensus. The court is no longer interpreting the Constitution. It's managing political crises through judicial fiat. That should concern every American, regardless of how they feel about Trump. The bigger picture. So let's connect all the pieces we've uncovered today. We began with a Supreme Court decision that seems straightforward. Can states remove Trump from the ballot? The answer was legally complex, but politically explosive. States have the authority, but must meet impossible procedural standards. We watched Trump's calculated response within minutes. Not a spontaneous outburst, but a coordinated messaging strategy that claimed total victory and put Republican opponents in an impossible position. We uncovered the deeper constitutional implications. A court rewriting Reconstruction-era provisions, centralizing power in federal institutions, and prioritizing democratic participation over constitutional text. We revealed the political calculations, Republican donors whose strategy collapsed, a party infrastructure paralyzed by institutional legitimacy given to Trump, and Democrats forced to confront a candidate they hoped the courts would disqualify. We exposed the media fragmentation, how the same decision was reported as complete Trump victory, constitutional crisis, and everything in between, with the most significant details buried under partisan narratives. And we traced the ripple effects, immediate policy changes, long-term precedent setting, and the quiet erosion of constitutional safeguards designed to protect democracy from authoritarian capture. The pattern is clear. We're watching American institutions bend under pressure rather than enforce clear constitutional standards. Each bend creates a new precedent. Each precedent makes the next bend easier. The stakes. This isn't just about Trump's ballot eligibility. This is about whether constitutional provisions mean what they say or what political circumstances allow them to mean. What's at risk if this pattern continues? The very concept of constitutional limits on power. We've seen this before in other democracies. Weimar Germany's constitution had emergency provisions. They were used to bypass normal democratic processes temporarily. We know how that story ended. Post-World War II, Italy wrote constitutional safeguards against fascist parties. Over decades, those safeguards were procedurally weakened until they were effectively meaningless. Modern Hungary and Poland both had constitutional courts that were supposed to check executive power. Those courts were captured, neutralized, and turned into rubber stamps. The American experiment has always been different because our institutions held until they don't. The call to awareness. Whether you lean left, right, or somewhere in between, this should concern you because the precedents being set don't discriminate by party.